Future interests. There are 6 future interests, 3 for the grantor and 3 for the transferee. Future interests for the grantor can be a possibility of reverter, a right of entry, and a reversion. The possibility of reverter is only paired with a fee simple determinable. Do you remember FSDPOR as Frank Sinatra dated the Princess of Russia? As we have discussed previously on the topic of the fee simple determinable, a possibility of reverter exists when an estate will return to the grantor if a condition is violated. The right of entry is only paired with the fee simple subject to condition subsequent. As we have discussed previously on the topic of the fee simple subject to condition subsequent, a right of entry exists when an estate will return to the grantor if a condition is violated and the grantor has the choice to take back the estate. The reversion. This is your default answer. Similar to the possibility of reverter and the right of entry, the reversion is the grantor's future interest that remains after he conveys an estate which is less than what he originally had. Here are some examples. O conveys to A for life. A has a life estate, and O has a reversion. O conveys to A for 50 years. A has a term of years, and O has a reversion. In both examples, O has conveyed a lesser estate than his original fee simple absolute. The reversion is limited to which estate it can be paired with. The reversion cannot be paired with a fee simple determinable because the possibility of reverter holds that spot, and a reversion cannot be paired with a fee simple subject to condition subsequent because the right of entry holds that spot, and a reversion cannot be paired with a fee simple subject to executory limitation because a third party's executory interest holds that spot. So the only possible pairings that are left are the life estate and the term of years. Thus, the reversion can pair with them. Future interest in the transferee can be a vested remainder, contingent remainder, or an executory interest. A remainder is a third party's future interest that is capable of becoming possessory at the termination of the prior estate. Said differently, it is the leftovers or remains after the original grantee is finished possessing it. For example, O conveys to A for life, then to B. Once A's estate expires, B gets the leftovers, so B has a remainder. A remainder can be either vested or contingent. A vested remainder is held by an ascertained person and is not subject to a condition precedent. Not being subject to a condition precedent means that there is nothing in the way or preventing the remainder from being possessed. A contingent remainder is somewhat the opposite in that a contingent remainder exists if it is held by an unascertained person or if it is subject to a condition precedent. There are 3 kinds of vested remainders: indefeasibly vested remainder subject to partial divestment, and a vested remainder subject to divestment. An indefeasibly vested remainder is certain to become possessory in the future and cannot be divested. It is the easiest to spot because the language that creates it is short and to the point. For example, to A for life, then to B. A is alive. A has a life estate and B has an indefeasibly vested remainder. Notice the language then to B. It is short and to the point. A vested remainder subject to partial divestment is a vested remainder that is held by a class, where at least one member is ascertained. The typical example of a class is children or grandchildren. For example, to A for life, then to B's children. A is alive. B has one child, C. A has a life estate, and C has a vested remainder subject to partial divestment. In analyzing a vested remainder subject to partial divestment, it is important to figure out when the class closes. A class is open if more members can still join. A class is closed when it is impossible for more members to join or when a member can take possession of the estate, i.e. when the prior estate ends, whichever happens first. This is an important note. Applied to our example, if B dies before A, then C's future interest changes. On B's death, C switches from a vested remainder subject to partial divestment to an indefeasibly vested remainder because B can no longer have children. Now for the last vested remainder, the vested remainder subject to divestment. We are discussing this last type of vested remainder right before discussing contingent remainders because I want to emphasize that this is the vested remainder that gets confused with being a contingent remainder, and vice versa. A vested remainder subject to divestment has a condition. For example, to A for life, then to B, but if B dies before A, to C. A contingent remainder can have the same condition. For example, to A for life, then to B if B does not die before A, otherwise to C. Take a few seconds to pause and realize that these two different future interests have the same condition. To tell the difference between them, you must focus on if B is packaged with conditional language. B can be packaged from the front, from behind, or both, but a comma after to B stops packaging from behind. If there is no packaging, then B has a vested remainder subject to divestment, but if there is any packaging, then B has a contingent remainder. Do not be confused and think that you are missing something. Students make the mistake of thinking that there is something more to understand. There is nothing more to understand. The vested remainder subject to divestment and a contingent remainder can be practically the same thing, except for different names. Further, for both the vested remainder subject to divestment and the contingent remainder, the condition is named something different. The condition in a vested remainder subject to divestment is named a condition subsequent, and in a contingent remainder it is named a condition precedent. We are able to conclude whether a condition is a condition subsequent or if it is a condition precedent only by first figuring out the future interest. For example, O conveys to A for life, remainder to B. However, if B does not live to reach 30, then to C. B is not packaged with any conditional language. There is no packaging from the front, and what looks like packaging from behind is not packaging because the comma is blocking it. Therefore, since we are dealing with a vested remainder subject to divestment, the conditional language if B does not live to reach 30 is a condition subsequent. In another example, to A for life and if B is 30, to B, otherwise to C, B is not packaged from behind, but if there was packaging, it would be blocked by the comma. However, B is packaged from the front with conditional language. As long as there is packaging of conditional language, we are dealing with a contingent remainder. Thus, the conditional language, if B is 30, is a condition precedent. Again, I repeat, we only know what kind of condition we have by first determining whether we are dealing with a vested remainder subject to divestment or a contingent remainder. Do not try to train your brain to make sense out of the names condition subsequent or condition precedent, because they will not always make sense. Therefore, just memorize that a vested remainder subject to divestment has a condition subsequent, and that a contingent remainder has a condition precedent. Moving forward with contingent remainders. Contingent remainders are created when there is an unascertained person or a condition precedent. Since we have just seen examples of when a contingent remainder is created with a condition precedent, here are some examples of when a contingent remainder is created because of an unascertained person. For example, O conveys to A for life, then to the heirs of B. A is alive and B is alive. The heirs of B are unascertained because they are only determined at B's death. Thus, being unascertained because B is still alive, B's heirs have a contingent remainder. Another example, O conveys to A's children who are alive when I die. O is alive, but we do not know which, if any, of A's children will be alive when O dies. Thus, A's children have a contingent remainder. Now, turn your attention to some historical rules regarding contingent remainders that the bar may test you on. The reason that the bar tests on these old rules is because new lawsuits may involve old property transactions. Rule of destructibility. The rule of destructibility has been abolished, but you still need to be familiar with it. This is the scenario. O conveys to A for life, then to B if he has reached the age of 18. The analysis revolves around what happens if B doesn't reach 18 by the time A dies. The rule of destructibility would have it that B has nothing, and the estate reverts back to O. But today's rule is more patient and waits for B. Until B reaches 18, O holds the estate. Thus today's analysis would have A with a life estate and B with a contingent remainder. When A finally dies and B is still not 18, O holds the land for B. So O has a fee simple subject to executory limitation, and B has a springing executory interest. Rule in Shelley's case. The rule in Shelley's case has been abolished, but you still need to be familiar with it. This is the scenario. O conveys to A for life, then to A's heirs. Today's analysis, which is the normal analysis, would have A with the life estate, A's heirs with a contingent remainder, and O with a reversion, since A could die without heirs. But the rule in Shelley's case made it so that A had a fee simple absolute, and A's heirs got nothing. The reasoning behind this rule was that A should be able to decide what his own heirs will inherit, instead of O. Note, this rule is a rule of law and not a rule of construction. Thus, O's intent is superseded by the rule. Doctrine of worthier title. The doctrine of worthier title has been abolished, but you still need to be familiar with it. This is the scenario. O conveys to A for life, then to O's heirs. In the normal analysis of today, A has a life estate and O's heirs have a contingent remainder. But with the doctrine of worthier title, O's heirs have nothing, and instead O has a reversion. The reasoning for the rule was to make it more easy to transfer land. For example, O and A could transfer the estate as a fee simple absolute without any trouble. Note, this doctrine is a rule of construction, so O's intent supersedes the rule. Thus, if O's intent was to create a contingent remainder in his heirs, then that intent is binding. So far we have seen two future interests that the transferee can have, the vested remainder and the contingent remainder. Now we will cover the last future interest that the transferee can have, the executory interest. An executory interest is a future interest in a transferee that can take effect only by divesting another interest. If the grantor is being divested, then it is called a springing executory interest. If someone other than the grantor is being divested, then it is called a shifting executory interest. Here are examples of both. O conveys to A and his heirs, if and when he finishes law school. A is still in law school. O has a fee simple subject to executory limitation, and A has a springing executory interest. O conveys to A, but if A leaves the premises in the next 50 years, then to B. A has a fee simple subject to executory limitation, and B has a shifting executory interest. While working through these examples, you may have been wondering why B did not have a remainder. B does not have a remainder because a remainder is a leftover. It's what is left after a present estate expires. An executory interest is not a leftover, and so it doesn't patiently wait for expiration. Instead, it cuts short someone's present interest. And as all future interests are paired with an estate, and since there is only one possible pairing for the executory interest, it pairs with a fee simple subject to executory limitation.